Hello students, good morning. I Rajesh Kumar Dev, Assistant Professor IMS Law College, shall discuss with you different provisions of international law. In this video, we shall discuss meaning of international law, definition of international law, functions of international law, and the nature of international law. What is the meaning of international law? According to modern approach, international law is the body of law that regulates the activities of entities possessing international personality. According to traditional approach, the conduct and relationship of states are important essential ingredients of the international law. Now, what is the international law? International law is simply a set of rules that countries follow in dealing with each other. There are three distinct legal processes that can be identified in international law that include public international law, the relationship between sovereign states and international entities such as International Criminal Court, private international law, addressing the questions of jurisdiction in conflict, and supranational law, the set of collective laws that sovereign states voluntarily yield to, but this basic definition must be supplemented with three more complex explanations. Is international really law? The law, the way the laws of the United States enforced by courts and police are, where do we find the rules of international law? Are they written down somewhere? Finally, how is international law enforced if there is no world government? Let us move to the next slide, please. The division of international law. International law has been divided into two parts, into two categories. First is public international law and second is private international law. Public international law is also known by some other name, that is international law. For private international law, there is also other name, that is conflict of laws. In the next slide, we have discussed what are the provisions of private international law. The body of law that regulates the relations between persons and entities in different states. Private international law is equivalent to conflict of laws. Means there is conflict between the provisions of two different countries. Then what provision will be applied to the resident or to the native member of the state, that will be decided by the provisions of private international law. Now, what is the definition of international law? International law is the collection of rules and norms that states and other actors feel an obligation to obey in their mutual relations and commonly do obey. This definition is according to Conway W. Henderson, Understanding International 2010 book. Definition of international law has also been explained by many authors, by many jurists. Oppenheim has also defined, Bentham has also defined the ingredients of international law. In the next slide, in the past, international law was commonly described as the law that regulates the relations between states amongst each other, or the system of legal norms regulating mutual relations between states, or the set of rules recognized by states and concerning their external relations, or the set of rules binding within the international community. According to the definition by Professor G.I. Tunkin, which is there in the next slide. Okay, let us move to the next slide, please. According to Professor G.I. Tunkin, an interesting definition of international law was formulated in the 1970s by a Russian international lawyer, Professor G.I. Tunkin. According to Professor Tunkin, definition of international law is that contemporary international law is the aggregate of norms which are created by agreement between the states of different social systems, reflect concordant wills of states, and have a generally democratic character, regulate relations between them in the process of struggle and cooperation, in the direction of ensuring peace and peaceful existence and freedom and independence of peoples, and are secured when necessary by coercion effectuated by states individually or collectively. There are some examples of international law or the recent definitions of international law. Some examples of more recent definitions of international law include the system of law regulating the interrelationship of sovereign states and their rights and duties with regard to one another. With regard to one another, in addition, certain international organizations such as United Nations, companies, and sometimes individuals, that is, in the sphere of human rights, may have rights or duties under international law. This definition or these provisions are given in Oxford Dictionary of Law 1997 at page number 240. Now, according to the Oppenheim, the definition of international law is a body of rules established by custom or treaty and recognized by nations as binding in their relations with one another. This is the definition given by jurist Oppenheim. International law, also called international law, is also called public international law or law of nations, the body of legal rules, norms, and standards that apply between sovereign states and other entities that are legally recognized as international actors. The international law was coined by the English philosopher. I repeat, the expression the international law was coined by the English philosopher Jeremy Bentham in 1784 to 1832. According to Jeremy Bentham, classical definition of international law is a collection of rules governing relations between states. It is a how far international law has evolved that this is that this original definition omits individuals and international organizations, the two of the most dynamic and vital elements of modern international law. In the modern time, the most important subjects of international law are international organizations and individuals too. Presently, there are three subjects of international law. First is states, second is individual, third is international organizations. Furthermore, it is no longer accurate to view international law as simply a collection of rules. Rather, it is a rapidly developing complex of rules and influential, though not directly binding principles, practices, and assertions, coupled with increasingly sophisticated structures and processes. In its broadest sense, international law provides normative guidelines as well as methods, mechanisms, and a common conceptual language to international actors, that is, primarily sovereign states, but also increasingly international organizations and some individuals. The range of subjects and actors directly concerned with the international law has widened considerably, moving beyond the classical questions of war, peace, and deploying diplomacy to include human rights, economic and trade issues, space law, and international organizations. Although international law is a legal order and not an ethical one, it has been influenced significantly by ethical principles and concerns, particularly in the sphere of human rights. The most important and famous jurist, Hugo Grotius, who is also known as the father of international law, has given the definition of international law. Now, what is the difference between international law and municipal law? In principle, international law operates only at the international level and not within domestic legal systems. A perspective consistent with positivism recognize international law and municipal law as distinct and independent systems. These are the provisions according to dualism approach. According to monism approach, there is converse. Advocates of natural law maintain that municipal and international law form a single legal system. An approach is sometimes known or referred as monism. Now, what is the nature of international law? Okay, let us move to the next slide for the nature of international law. Today, international law refers to those rules and norms which regulate the conduct of states and other entities which at any time are recognized as being endowed with international personality. For example, international organizations and individuals in their relations with each other. Rebecca M. Wallace, International Law, Sweet and Maxwell publication. This is the book of 1995 at his page number first. This nature has been explained. Let us move to the next slide, please. Is international law a real law? International law is a practiced on a daily basis in the foreign offices, national courts, and other governmental organs of states. The evidence is that reference to international law has been a normal part of process of decision making. This was explained by Brownlee, a famous jurist. States do not claim that they are above the law or that international law does not bind them. In the next slide, the overwhelming majority of international legal rules are consistently obeyed, has been given. According to L. Henkin, the definition or the nature of international law is it is probably the case that almost all nations observe almost all principles of international law and almost all of their obligations almost all of the time. The book of L. Henkin, How Nations Behave, at page number 47, described the nature of international law too. Basics, characteristics of international law. They are as follows. International law has only a limited number of developed legal institutions. In comparison with national law, international law is decentralized. The nature of international law also contains the provisions that there is decentralized international lawmaking, there is decentralized international law enforcement, there is decentralized voluntary international law adjudication. Now, why is international law binding on states and other actors? There are three theories regarding this. First is known as the command theory. Second is the consensual theory or consensus. Third one is the natural law theory. Now, what are the different functions of the international law? Functions of international law are as follows. First function is that to arrange for the cooperation between the state or most actors wish to have most of the time. Second function is to identify the membership of an international society of the sovereign states. Third most important function is that to regulate the competing interests of the various actors and to carry their agreements into the future. Next function is to empower weaker states as they press for change against the will of the powerful, to promote justice and to outlaw the war. These are the important functions of the international organizations or the international law. While we discussed the nature of international law, so many things are required to be kept in mind. According to the nature of the international law or the law of nations, international law is not a true law. It is a code of rules of conduct of moral force only. Another view is that international law is true law and it is to be regarded as law in the same way as that of ordinary law of state, which are binding upon the individuals. The reality is that answer of the above question depends in a large measure upon as to what is the definition of term law. It alone would decide whether international law is a true law or not. According to the definition of Austin, Hobbes, Bentham, Pumferdorf are of the view that international law is not legally binding on the state. In the 19th century, a number of prominent jurists took the similar view. The most prominent amongst them is British jurist Austin and later his followers. According to Austin, law is the command of the sovereign, attended by sanction in case of violation of the command. In other words, law should be limited to rules of conduct enacted by a determinate legislative authority and enforced by physical sanction. The superior, according to him, is the real sovereign. The definition contains two important elements. Firstly, law is a command enacted by the sovereign legislative authority. Any rule which is not enacted by sovereign or superior cannot be regarded as law. And secondly, command must be enforced by the sovereign authority. That is, if laws are violated, these laws should be adequate. There should be adequate sanctions behind it. It was his view. It was the view of Austin that international law cannot be called law proper in the true sense neither because it has neither sovereign legislative authority to enact law nor there is an adequate sanction behind it. Moreover, there is no enforcement agency which can enforce it as the body of rules. The criticism has also been made by many of the jurists. The definition or the views which have been given by the Austin have been criticized. First criticism was given by Maine. Second criticism given by Pollack, and last one is Price. All these jurists criticized the definitions or the views or the nature of international law given by Austin. Ultimately, the basis of international law are different theories. First is the natural theory, second is the positivist theory, and last one is the eclectic theory. And in all the theories or all the definitions or all the views given by eclectic theory are very important and they are applied at international level by the international community. In this period, thank you so much. We shall be meeting in the next period. Thank you. Namaskar.